5 years. We have recently started awareness campaign on cyber fraud in association with Mumbai Police Cyber Crime Wing, and very soon we are going to have such program online for this audience also of various societies. Only date need to be finalized. In principle, agreement has already been done. We have adopted a lot of schools in Palghar. We have blood donation camp. Since July, we have done 10 blood donation camps here. We have one of the very important project we started, Swam Siddha, where we are supporting or empowering divorced women, making them self-reliant with the help of family court Bandra. We are starting IT Innovation Center, where IoT, 3D printing, robotics, data science are going to be taught to youth from 18 to 30 years of age, and they will be mapped to their jobs. Yoga classes are regularly running in association with Yoga Institution at Rotary Center. So a lot of such programs are there, and so I also welcome you guys to come and be a part of Rotary Drive, where we are serving the community, service above self. With this, I would like to hand over today's proceeding to Ramesh Prabhuji for the important topic, which is the redevelopment on private land. So, Ramesh, over to you.
Yeah, thank you, Dharmesh Sharma ji. Of course, redevelopment has become a talk of the town, and it has a lot of legal implications. Most importantly, when we go for a cooperative housing society's redevelopment in a private land, which is owned by the society, or it may be on the lease basis. So we encounter so many issues, especially the legal issues regarding the procedure adopted, transparency adopted, or various things. So we have with us Advocate Amit Mehta, who will be definitely dealing with the legal issues that need to be taken care by a cooperative housing society when they are going for redevelopment. And let me introduce Advocate Amit Mehta. Yes, Amit, you are there?
Yeah, I'm very much there. I'm very much
okay.
there. Yes.
So let me briefly introduce our speaker of the day, the first speaker. Thereafter, we'll definitely take up with the Sandeep Kangutkar, who will be dealing with the feasibility report and the role of the project management consultant. And at the end, of course, I will try to conclude with the various challenges that the housing societies are facing in the completion of the redevelopment. So with that, let me just introduce you to Advocate Amit Mehta, who has been recently awarded by Maharashtra Society Welfare Association, also as one of the leading advocates in Maharashtra. So with that, Advocate Amit Mehta is a practicing partner of leading law firm called Solex Lex, and especially they are experts in the redevelopment, housing society related matters, and of course MRTP and various court matters. Now, he was a BJP candidate for the MLC election held in the year 2018. He is recently appointed by the Maharashtra Cabinet Minister of Technical and Higher Education, Honorable Sri Chandrakant Dada Patil and Sri Vikas Chandra Rastogi, the IAS officer, Principal Secretary to Academic Council of National Law University. This is a part of the governing council that overlooks administration and curriculum of 22 NLU, that is National Law University across India. In Mumbai, NLUC is, that is National Law University, is situated in Powai, Hirandani Gardens. Currently, Justice D.Y. Chandrachud, Chief Justice of Supreme Court of India, is the present councillor along with other judges as a member of Governing Council of National Law University in Center. So he is, as I said, is one of the leading advocates and regular faculties across board, whether it is a PIETA or MCCHEC, CREDAI, or any leading organizations. And I don't want to take much of your time, but I can only tell you that he will deal with the redevelopment, the challenges that the housing societies face in the process of redevelopment. Over to Amit, you can take 10 to 15 minutes, then we'll have few questions to be answered by you regarding the legal issues. Thank you very much.
So thank you, Ramesh ji. Thank you, Dharmendra ji. Incidentally, Dharmendra ji, I am also member of Rotary Club, Rotary West Coast. So I've been long time associate with Dr. Bal Inamdar and Neelam Inamdar.
Most welcome.
And of course, I've been associated with Ramesh Prabhuji also for quite some time, where we have been spearheading a lot of issues related to cooperative societies across Mumbai and Maharashtra as such. So thank you very much for giving this opportunity to me by the MSWA, Ramesh Prabhuji, Sunilji, and the entire Mahaseva News team. I'm sure that, redevelopment is the most burning issue today in Mumbai. If you see across Mumbai, the entire action of redevelopment has now shifted to suburbs. You can say from Bandra to Dahisar. That is the main place from where the action has started as far as redevelopment is concerned. And crores of rupees have been are being spent by the government also in rehabilitating people. There are different models of working redevelopment. The biggest question and the challenge that lies with the members of the society is how to tackle redevelopment. And let me tell you that even though you keep the consultants, the good consultants across Mumbai for this, maybe as a consultant for all inspecting this procedure, but you yourself are your own advocate, you yourself are your own PMC, you yourself are your own quality engineer, and your involvement on day-to-day basis, time to time, will help you enable the completion of the project on time. You would also have known that since RERA has come into existence, Ramesh Prabhu did tell a part of the profile, but I would also like to tell the viewers that we are also part of the RERA drafting committee from 2014 onwards. When the new government, Modi government came, we are part of the RERA drafting committee. And in 2016 May, it was successfully implemented across India and in different states with slightly different type of amendments in each state. Today, RERA has been successfully promoted and propagated by the government nationally. So we have one country and one real estate law. This is a big achievement for the government as such, because what had happened earlier, there was no single law which was binding on anyone. But now that there is one country, one law, it enables people and they are safeguarded. I'd also like to tell you that, the 79A procedure, which is very important, though it is not mandatory in nature and it is directive in nature. You would have seen the recent judgment also of the Honorable High Court. But it is very important to safeguard your own interest, especially members of the society where they are large in numbers. If you're few in numbers, maybe 10, 15 or 20, or if your plot size is smaller than 1,000 square meter or maybe 700 square meter, then it is okay. But if you're a large size society, then it is better that, you have proper regulatories in place and proper consultants in place. You'd also have known that, the government of Maharashtra had issued this circular in somewhere in 3rd of January 2009. And under this section of 79 procedure, the object was to bring clarity and transparency in the redevelopment process of the society building and also for the smooth functioning of the society. So since there were no prescribed guidelines earlier, when the redevelopment procedure started across Mumbai, but in 2009, the government did prescribe these guidelines. It is not a standard practice which was earlier adopted, but now due to this, there is a lot of transparency which has come, the confusion has come down, and of course, the litigation also has majorly come down. The directives there were under this procedure. Okay, the government had already notified through an IS officer, where he had basically put up a small survey and a small study within the societies and within Mumbai. And finally, it came into the existence in 2009. If members would know that, when your society is there and especially redevelopment takes place, the people who have never been dissenting also start dissenting. And this is because many times there have been managing committees who have been overpowering most of the members of the society, and they do not keep transparency in the entire procedure. The members normally are not taking into confidence in the process of development. There was always a lack of transparency. Appointment of contractors or developers was in a haphazard manner. There are lots of gross violations also which were happening in the rules and regulations and even the bylaws. There was no proper coordination between the architects and the project consultants who were executing the project. You would also know that now we also take out a feasibility report, and this feasibility report actually comes and gives some guidelines earlier this reports were never prepared. So the government also stipulated some guidelines that a feasibility report be prepared. And based on this, the study group which was formed under the chairmanship of a joint register of cooperative societies of SIDCO, the circular was finally issued on 3rd of January 2009, and certain procedures were prescribed. Let me tell you in short the procedures which were normally prescribed under this guideline. One is to call SGM. Note that all SGMs have now to be video group photographed. If you don't video photograph, someone may try to hook you on a technical grounds. Though you may be keeping transparency, but still this issue may remain. Call the special general body meetings, receive written suggestions from the members for redevelopment of the building, submit the outline of the program for redevelopment, take decisions in this special general body meeting, and circulate the minutes of meeting to all the members. It was also with the purpose to issue a proper letter of appointment to an architect or a PMC, the legal advisor whom we are going to appoint for looking after the entire legal work and the paperwork, and all the guidelines of the architects and PMC, whether it is pre-construction or post-construction, is to be stipulated in an agreement or appointment letter, which we are normally issuing it to the PMC. Please note that the feasibility report, which is being made by the PMC, is merely a guideline, and you cannot hold them that you had earlier quoted this and now you are telling that the changes will be so and so. Please understand the rules and the laws change very fast, but the consultants need to be aware. You cannot appoint a consultant, or you should not appoint a consultant who has half knowledge. It is very dangerous. It may lead to crores of losses as far as your society is concerned. Coming to the procedure of redevelopment, you would know that once you appoint consultants, namely the legal advisor and the PMC or architect, you issue appointment letters to them, pay their advance fees, you book them, and then the procedure of tendering starts. Normally, any society would call for tenders of 5 or 10 developers. It is my humble submission that when you are calling for tenders, ensure that you also keep a sort of pre-qualification before issuing a tender. The reason I am telling that we have been seeing litigations across Mumbai where some developers enter into a society with a mere 20-30 lakhs of balance sheet and then give higher offers. The higher offers and lucrative offers are given only to lure you into more trouble, and members become greedy. And because of the greed, they ultimately end up giving the project to a developer who did not have any experience, and then he may be having a very small balance sheet. And because of this, he was not able to survive in the entire cash flow as far as the project implementation is concerned. Hence, selection of developer through the tendering process is very important, but pre-qualification of who will collect my tender also is equally important. The selection of developer, you would know that there are certain criteria we follow. If I have to tell you the top 5 criteria which we would follow as a legal advisor, and I'm sure the PMC also would vouch for that. One is he should have a proper balance sheet and profit and loss statement. Second, they should give a solvency certificate. Third, try to take the OC copy of the last 3 projects which they have completed. This would enable you to actually have a sort of certificate that the developer is not only completing the project on time, is also going and getting the OC also. You would know today half of the Mumbai has always been suffering because of lack of OC in many buildings. You would have seen in articles today that 50% of the societies either don't have conveyance or don't have OC. This is purely because the members have never been vigilant. The MOFA was largely there, but the execution part of the MOFA was not implementable due to lots of issues. Hence, when the criteria is finalized, ensure that this is one of the criteria which has been taken care of. Fourth important point when selection of developer, try to meet up the people of earlier societies and check out how was their experience with this particular developer. And fifth is more important, that ensure that all your documentation, such as development agreement, power of attorney, if at all you are taking a security, then the security escrow letters or agreement copies or bank guarantees or any other security which you are keeping, the PAAA, that is called Permanent Alternate Accommodation Agreement. All these documentation are watertight. Please note, the entire case of a redevelopment would depend on only two documents. One is development agreement, which ought to be a registered development agreement, and a power of attorney. The power of attorney need to be not be said, but you understand it has to be given to a developer for him to execute this project. As far as development agreement is concerned, you would know that a development agreement would play a very important role. That's the only document on which the entire society survives. And you would have known a case in Supreme Court where the judge has given a judgment that if there is no registered development agreement between a developer and a society, the society is free to go ahead with another developer, unless and until a major amount has been taken by the society, either in terms of corpus or rent or some sort of EMD and security deposit. But these all payments are or can be returned, and you cannot be holded for not proceeding ahead with the development if your developer delays the project over a period of time. Now, as far as the selection of developer is concerned, you would know that sufficient quorum is required. Normally 70-30 was the ratio which was required under the guidelines of 17A procedure. Then MHADA took out a circular and then it became 51-49. Now, most of the MHADA societies today are practicing under the guidelines of 51-49. So even though my 49% of the people are in opposed to me, I can still go ahead unless and until they have a striking reason why we should not go ahead with a particular developer. Please execute the minutes of meeting and pass the appropriate resolutions with appropriate wordings. Please note that the resolutions and the minutes of meeting should be properly vetted by your PMC as well as a legal advisor, because these documents would carry a lot of weightage in future, and it is very important for you to know that documents play a very important role. If you are right, but you have no documentation, you are wrong. But if you're wrong and you have some documents to prove that where you are today, you may still be heard by the court. You would have also seen a very classic case of Ganpati Niwas in Goregaon in Bangunagar area, where a minority was holding at ransom to the majority. And Justice Gautam Patel at that point of time had given a very classic judgment somewhere in 2016-17. The judgment I will put up in the group later on, and I'll request Ramesh Prabhuji and the team to forward it to the people at large. And a very good Times of India article also had come. Please don't get frightened by dissenting members. Dissenting members cannot stop your development. There are a couple of 2 or 3 classic judgments. However, there should be note of caution also that even though you have a classic case, and the classic case is that you are not a dissenting member and you are with the society, but if the guidelines are not followed, then you will always be hooked up by some dissenting member or the other. So please ensure that many of the documentation which you are doing are vetted through properly, even with the members of the society. Please give sufficient time to members of society. Please don't rush with the documentation, because this documentation, sometimes there could be some errors even by the consultant. And it is important for the consultants to understand that members may sometimes point out some important points, and that may be considered. Lastly, I would also like to tell that redevelopment procedure now has taken a very different shape in a city like Mumbai. Now you have one country, one tax law also. So GST implications are there. How, whenever you are getting a free area, then what words to be used, like displacement compensation and hardship compensation words we use, so that you are not taxed also, because these amounts which you are getting as corpus and rent are not taxable. So Ramesh Prabhuji, thank you very much. I wanted to be short so that I can listen to people, have their queries, and then we can answer them, because this is the right forum to at least answer them. Otherwise, it is always a one-way procedure where we just give a bhashan and then they are never getting their answers also.
Yeah, Amit, thank you very much. Now, I will be definitely asking you the question after the presentation by Sandeep Kangutkar.
Yes.
Especially regarding the stalled project, where the developers, more than 5,000 projects in Mumbai or MMR region are stalled, and for various reasons. I think many of the projects also you have led with up to the High Court and terminated the developer and facilitated the societies to appoint a new developer. So that is again a new process post RERA, how the effects will happen to the flat purchasers and the, of course, existing members, how their rights can be protected. All these questions will come up after the presentation by Sandeep Kangutkar. especially on two aspects. In order to start a redevelopment, Sandeep Kangutkar is a leading architect, and he is a second generation architect. His father was also an architect, and his firm is functioning for the last 30 years. Now, uh, he has been the PMC and the architect for number of societies for the self redevelopment also, and also for selecting the developers and taking care of the societies in the process of redevelopment. He is the managing director of One Stop Project Management Consultants Private Limited, and as I said, he is a member of Council of Architecture, and he has a wide experience regarding the revival of the stalled project also, where around 3 stalled projects have been managed and taken over by him, and now the projects have come to the stand of implementing or rather obtaining the OC, and people have started occupying the premise also under the fit out position. So we have with us Sandeep Kangutkar. Sandeep Kangutkar, you need to highlight how we can start the process of redevelopment and what is the role of a project management consultant, whether it is advisable to appoint a project management consultant, who are the people involved in the project management consultant, and then last is feasibility report. Mr. Advocate Amit Mehta has rightly pointed out in the beginning only that to start the process, you have to have a feasibility report. What do you mean by this feasibility report? What are the various inputs that you need from the societies, and what is the output, and what the society, how the guidelines are given to the society by way of a feasibility report? So over to you, Sandeep Kangutkar.
Thank you very much for calling me on this dais, and this is a wonderful dais, and I also not only give the lectures, but I also learn various things from the various speakers. So this is a wonderful opportunity for everyone who are not only the speakers, but also for the viewers also. So thank you very much. And I do good morning to everyone, and I will start the thing. The first of all, I will continue what the earlier speaker has said. The importance of appointing a legal advisor or a PMC or an architect before starting the redevelopment process. Obviously, as per the norms of the government directions, it is mandatory to appoint a project management consultant, but there are various court judgments. If any society is not appointing a PMC also, but there is a majority, you may continue. But looking at the importance and the very seriousness about the redevelopment process, it is important to appoint a good project management consultant to entire redevelopment process, wherein in a PMC you should have first of all is an architect, then there should be a legal advisor, there has to be an engineer, and many other aspects has to be considered while giving the project management consultancy. First of all, when we start consultancy as a PMC to any society, the most important thing is the feasibility. Because unless and until you're not understanding the volume of your project, you will not come to know where exactly you want to go. So in the feasibility, we can understand what is the total construction area, what is the total carpet area, what could be the project cost, including the approval cost, including the construction cost. All these aspects will cover in the feasibility, and what you can expect from the redevelopment. So once your views are clear, you can definitely go smoothly in the next process of the redevelopment. So for preparing the feasibility, you require certain basic documents that society should have. That is, you should have your approved plan copy, you should have your commencement certificate, you should have your OC certificate. Generally, the societies are not so particular for storing these very important documents, and they don't understand the gravity of these documents. And one society, we were the PMC, and they have been selected as a post selection of the developer. And when they have submitted the plans to the MCGM, MCGM refused to give the free fungible. This is just an example I'm giving what is the importance of the having a documents with the society. And then they said that you don't have the approved plan copy, you don't have the OC certificate, so we will not be able to give the free fungible. Then developer said, that it is the responsibility of the society to give me the approved plan copy, to give me the OC certificate. And unless and until these things are not provided to me, I'm not in a position to pay the premiums unless and until you do the bargain with me for additional area. So that was the dispute point. So I request all the society members to organize their office in a such a way they have all the required documents which are necessary to go for the redevelopment. Once your PMC goes through your documentation, he will prepare a feasibility report. And the feasibility report, why it is important, not only it gives you the what it could be the additional carpet area, what could be your additional corpus, what could be rent. That is the only information is not given in the feasibility report. You will also get what is the quantum, कि ये प्रोजेक्ट का कॉस्ट कितना है और ये प्रोजेक्ट के लिए कौन सा डेवलपर आ सकता है. So that is also very important. जैसे अर्लियर एडवोकेट अमित जी ने कहा था कि बिफोर अपॉइंटिंग अ डेवलपर यू शुड ड्राफ्ट अ प्रॉपर टेंडर डॉक्यूमेंट्स. तो वो टेंडर डॉक्यूमेंट में ये सब पैरामीटर्स की ये प्रोजेक्ट का कैपेसिटी और डेवलपर का कितना होना चाहिए, उसका जो क्राइटेरिया हम लोग डिसाइड करते हैं उसका नेटवर्थ कितना होना चाहिए, ये सब हम लोग टेंडर में डाल सकते हैं. और इसके बाद जब टेंडर लेंगे तो लिमिटेड डेवलपर्स और जो कैपेबल डेवलपर्स है वही इस रीडेवलपमेंट प्रोसेस में हिस्सा ले सकते हैं. अगर किसी ने दे भी दिया तो ये सब पैरामीटर्स अपने को टेंडर में इनकॉर्पोरेट करना जरूरी है, ताकि आगे चल के रीडेवलपमेंट में कोई भी जो डेवलपर है जो ज्यादा ऑफर देता है लेकिन उसका कैपेसिटी नहीं है, वो प्रोजेक्ट के लिए बाधा नहीं डाल सकता है. सो दिस इज द वेरी इंपॉर्टेंट एस्पेक्ट while preparing the tender documents or the criteria for the finalization. Then the documentation में जो advocate अमित जी ने कहा था कि it is very important to have the proper development agreement, proper power of attorney. But development agreement का base भी tender document होता है. So your tender document, that is the first legal document which you give to the developers to fill up and give back, is also very important, because on that basis our development agreement takes a shape. So ये सब करने के बाद once we go for the actual redevelopment, we should see that जो plan जो developer बना रहा है, it is as per the requirement of the society. Because if the plans are not as per the requirement of the society, again it is of no use, because redevelopment we are not doing for the developer, we are doing it for the society purpose. So the planning aspect is also be checked by the PMC, what kind of plans he is preparing, और जो plan बनाया है वो as per the requirement है कि नहीं है, वो भी देखना बहुत जरूरी है. Then after submission of the plans, उसने जो जो conditions fulfill करनी है in the authority, whether he has done all these permissions correctly or not, that is also the responsibility of a good PMC. जब वो पूरी conditions fulfill करेगा तभी अपने members को हम लोग building vacate करने के लिए guide कर सकते हैं. So this is also very important, because आप देखेंगे कि बहुत सी buildings जल्दी vacate कर देते हैं और कुछ कुछ कंडीशंस ऐसी रहती है जो फुलफिल करना डेवलपर के लिए मुश्किल हो जाता है, और बाद में 2-3 साल वैसा ही काम चालू रहता है. मींस people are out of their premises, builder is not paying the rent, so all these complications बढ़ जाते हैं. उससे पहले ही हमें अगर मालूम पड़ता है कि बिल्डर ने ये सब कंडीशंस फुलफिल की है, तभी हम अपने मेंबर्स को बिल्डिंग वेकेट करने के लिए इजाजत दे सकते हैं. और दूसरी बात कि जो बैंक गारंटी वगैरह है, तो वो बैंक गारंटी अगर डेवलपर ने प्रॉपर दी रहेगी तो, लेकिन बैंक गारंटी इज नॉट द ओनली क्राइटेरिया, क्योंकि बैंक गारंटी को एक्चुअल यूज करने के लिए भी बहुत टाइम लगता है. इट इज वेरी रेयर केसेस कि हम देख सकते हैं कि बैंक गारंटी भी किधर यूज कर. इसके लिए प्रॉपर सिलेक्शन ऑफ द डेवलपर, दैट इज वेरी इंपॉर्टेंट. और मेरे ख्याल से दिस इज व्हाट आई कैन से about redevelopment in a private property. In a private property ka redevelopment, and there is this is the topic in today's scenario, is a private redevelopment. Private redevelopment में जो माड़ा की buildings है वो include नहीं होती है, SRA नहीं है, on the collector's land it is not included. Only the private buildings which are have a clear title and they are not in the MADA or in a SRA or in a CES category, so it is the private redevelopment. Babu sir, please.
Yeah, सर पहला सवाल ये है आपको कि रीडेवलपमेंट करते टाइम अलग अलग प्लॉट का अलग अलग ऑफर्स आती है. फॉर एग्जाम्पल, कुछ प्लॉट में 35% देते हैं, कुछ जगह में 20% देते हैं, कुछ जगह में बिल्डर 50% भी देता है. तो रीडेवलपमेंट करते रहे वो बोलते हैं कि आपका रोड विड्थ का ये प्रॉब्लम है, आपका सेटबैक ज्यादा जा रहा है, you are not in a position to get fungible FSI. You are not. So we as a layman, housing society, office bearers or a committee are not able to understand. तो आप ये बता पाएंगे कि what is this development control provision in which different type of FSI, TDR, fungible FSI अलग अलग क्या होता है, रोड विड्थ का क्या मायना रखता है, क्या ये सब फिजिबिलिटी रिपोर्ट में आप कवर करते हैं या किस तरह से फिजिबिलिटी रिपोर्ट बनाया जाता है?
Obviously, it is a very in-depth subject, but I can tell you very shortly कि एक प्लॉट में अगर कोई डेवलपर 35% ऑफर कर रहा है, तो इट इज नॉट नेसेसरी कि उसके बाजू वाला प्लॉट में भी वो 35% ऑफर. आई एम जस्ट गिविंग एन एग्जांपल कि एक रोड पे जो बिल्डिंग है तो वहां पे डेवलपर इज ऑफरिंग 35% और दूसरे प्लॉट में कहता है कि योर प्रपोजल इज नॉट वायबल. तो ऑल ऑफ अ सडन बाजू की सोसाइटी बोलते हैं तो बाजू का डेवलपर जो उनको 35% दे रहा है और आप बोल रहे हैं हमारा प्रपोजल वायबल क्यों नहीं है. तो देयर आर वेरियस रीजंस. एक तो आपका कंजम्पशन इन द प्लॉट कितना हो गया वो इम्पोर्टेंट है. बाद में ये जो रोड विड्थ है,
what do you mean by consumption on the plot? Can you explain what do you mean by consumption on the plot?
कंजम्पशन मतलब कि अगर आपका मैं जस्ट 1000 स्क्वायर मीटर का प्लॉट है और आपके प्लॉट में अगर 1100 या 1000 स्क्वायर मीटर का कंस्ट्रक्शन हो गया 1000 स्क्वायर मीटर का, तो 1:1 आपका प्लॉट का कंजम्पशन हो गया है. कोई कोई जगह पे बिकॉज ऑफ द वेरियस प्रीवियस सेटबैक और कुछ अलग रूल्स के वजह से अगर आपके प्लॉट में 1500 स्क्वायर मीटर कंस्ट्रक्शन हो चुका है तो ऑलरेडी यू हैव क्रॉस द लिमिट of 1:1, means you have consumed 50% more than the prevailing, means that as per the present policy. तो बाद में जो एडिशनल एफएसआई देने का एडिशनल एरिया जो डेवलपर को कंस्ट्रक्ट करने को मिलेगा वो बहुत कम मिलेगा, क्योंकि अभी एफएसआई कैप है. एफएसआई कैप इज उसके ज्यादा हम लोग कंस्ट्रक्शन नहीं कर सकते. दैट इज द डीसीपीआर में ही रेगुलेशन नंबर 30 एफएसआई कैप इज डिफाइंड. अगर कोई रोड 9 मीटर से छोटा रहे, मीन्स कोई प्लॉट फ्रंटिंग लेस देन 9 मीटर, उनको सिर्फ एक ही एफएसआई मिलेगा. जो 9 मीटर से 12 मीटर तक है तो उनके लिए 1+1 एफएसआई, दैट इज 2 एफएसआई इज परमिसिबल. 12 मीटर से 18 मीटर के लिए है तो 2.2 एफएसआई. 18 मीटर के ऊपर है और below the 27 meter you will get 2.4 FSI, and more than 27 meter you will get 2.5 FSI, and over and above this FSI 35% fungible is also permissible. तो road width के हिसाब से हमें FSI मिलता है. So this is hello.
हाँ, अपना ये जो FSI मिलता है depending upon the road width. Now in the service road, now I understood that even highway is considered as a part of width. Is it so?
Yes, correct. But highway and the service road should be at the same level. Otherwise, if the highway there is a bridge and your service road is below the highway, so because the access from where you are taking, that is more important.
Okay.
Yeah. So Sandeep ji,
yes,
what we are trying to say is, in the case of a feasibility report, first and foremost is what is the FSI presently used as versus the available of the plot. That is very important to be considered. If there is a work consumption, if the built up area is more than what was available with one FSI, additional, that will be, disadvantages. Second, you said, yes, road width is very important. If the road width is more than 9 meter, then only you are able to take a FSI, TDR and fungible FSI. If it is less than 9 meter, actually you will not be able to load the TDR. So then you are not able to load the premium FSI. What you can do is only the available present FSI plus 35% fungible FSI, which means the redevelopment does not become viable. So 9 meter road width is a very important.
Right.
Third thing you said, yes, if the road width is more, then the FSI instead of 2, then it can be 2.2, 2.5, 2.4, and so on.
2.2.
And you also said there is something called cluster development. Can you explain what is cluster development? And in a housing society, for the suburb and in city, what is the area required for the cluster development? And because of the cluster development, what is the road width required and how much FSI they can get?
Yeah, in a cluster redevelopment, the basic criteria in the suburb is to have a 6,000 square meter plot area, and in the city it should be 4,000 square meter. So अगर आपका सोसाइटी का प्लॉट एरिया 3,000 स्क्वायर मीटर है और बाजू का 2,000 है और उसके बाजू का 1,000 है, तो तीन सोसाइटीज का प्लॉट मिलके अगर 6,000 स्क्वायर मीटर होता है, then you are eligible for go in the cluster redevelopment in the suburbs. Likewise, in the city, you should have a minimum 4,000 square meter plot area. And minimum road width, earlier it was 18 meter, now it has been reduced. अगर आपका 12 मीटर का भी 12 मीटर के ऊपर का रोड रहेगा तो you are eligible, मीन्स उधर से अगर आप रोड का width लेंथ कैलकुलेट करेंगे तो you are also eligible, और commissioner may consider your file to go for the cluster redevelopment also.
Okay, so by
cluster redevelopment में आपको चार FSI मिलता है, और जो आपका एग्जिस्टिंग एरिया है उसके ऊपर इंसेंटिव FSI मिलता है, दैट इज इंसेंटिव FSI प्लस फंजिबल, और जो अपने को शेयर करना पड़ता है माडा के साथ, वो सब कॉम्बिनेशन करके भी क्लस्टर रिडेवलपमेंट इज उसमें ज्यादा बेनिफिट्स है. लेकिन मेजॉरिटी ऑफ द सोसाइटीज थिंक दैट कि बाजू के सोसाइटी के साथ अपना कैसा जमेगा. तो माय humble request to the societies is that try to get the in a cluster, because cluster में अपने को ज्यादा amenities भी देने हम लोग दे सकते हैं.
You are advising that it is better to go for cluster development.
Yes.
Correct? Yeah, Nikita, can you put yourself on the mute, please? Oh, Mahaseva, yeah. Okay. Sandeep ji, the next question is, there is people who say, and you also said, that there is something called free FSI. That is a fungible FSI which is given free of premium, and there is some fungible FSI 35% which is given by cost. Now there is a misconception among number of people that fungible FSI is free of cost, therefore it has to come to the members. And naturally, if I have got 100 square meter, say flat, say 1,000 square foot, I should automatically get 135 myself, plus another 35% should be given by the builder. So like this, I should get 70% additional, benefit in the redevelopment. How you look at it? You are on mute. Unmute yourself.
Yeah. There are a lot of misconceptions about the fungible FSI in the society members. Generally, they feel that this fungible FSI has to be given, means entirely free of cost to the members. But looking at the viability of the project, we have to check it out whether 35% is possible or not. If the 35% is not possible, if the developer is giving say 20%, then the 15% of the fungible he cannot use in the cell component. That doesn't mean कि 15% भी उसको अपने members को ही देने का है. अगर ये 15% he is not giving to the existing members, then definitely he is not allowed to use it in the cell component. That's all. Otherwise वो cell component में use नहीं कर सकता. इतना ही fungible का ये है. Agar if the project is looking at the viability, if it is feels that the 35 after giving the 35% to the existing members, developer may use as a free component, and the balance sellable component he can use it in the cell component. That all depends on the feasibility report.
Sir, what happens in the redevelopment is the base area. That means the existing area. Now people, in the existing area there is something called area as per the approved plan. Then a lot of societies have encroached the balconies. There are free of FSI the terrace. Now people do demand, and the area as per the approved plan, area as per the BMC assessment, area as per the agreement, area as per the, actually occupying. They are all different areas.
Right.
So at the time of redevelopment, what is the area that is to be considered as a base area? Whether balcony which is there, can I expect that to be part of the FSI? And then I can take the benefit. Let us say my area is 500 square foot, 100 square feet is my balcony, so I've got 600 square foot. I will get the benefit on 600 square foot, that is 35% on 600 square foot, or on 500 square foot. This need to be clarified.
Okay. Generally, there are various carpet area parameters that society shows to the PMC or the developer. One is their approved building plan copy, one is the assessment tax, one is the actual measurement, one is some encroachment. But the basic criteria for authenticity of the existing carpet area is as per the approved plan. And as per the approved plan, only society should get additional carpet area. Then there should not be any dispute. अगर किसी ने कुछ एनक्रोचमेंट किया है तो एनक्रोचमेंट हम लोग जनरली नहीं कंसीडर करते फॉर देयर एग्जिस्टिंग कार्पेट एरिया. अगर किसी की बालकनी है बराबर, तो बालकनी उस टाइम में 10% ऑफिशियली मिलती थी सब डेवलपर्स को, और डेवलपर लोग बेचते थे एग्जिस्टिंग मेंबर्स के लिए. तो मेंबर्स अभी कहते हैं कि ये बालकनी हमारे फ्लैट के साथ अटैच है और इट इज ऑफिशियली देयर इन द अप्रूव्ड प्लान कॉपी ऑल्सो. तो जनरली फॉर जब हम लोग फिजिबिलिटी रिपोर्ट बनाते हैं तो जो कैलकुलेशन का पर्पस रहता है तो वहां पे हम लोग बालकनी एरिया डिडक्ट करते हैं फॉर द फ्री फंजिबल, और उसके बाद में जो सेलेबल फंजिबल है वो कंसीडर करके पूरी फिजिबिलिटी निकालते हैं. लेकिन जब एग्जिस्टिंग मेंबर्स को हम लोग एडिशनल एरिया देते हैं तो जनरली हम लोग ट्रेंड ये है कि अगर उसको बालकनी एरिया भी हम लोग कंसीडर करते हैं तो उसके बाद हम लोग कितना एडिशनल कारपेट एरिया इंक्लूडिंग हिज बालकनी दे सकते हैं वो देखते हैं. बिकॉज फंजिबल कितना पे करने का कितना नहीं करने का दैट इज ओनली द कमर्शियल टर्म्स. लेकिन सबका जो बालकनी रहता है दैट इज अ वेरी ऑफिशियल एरिया दैट हैज बीन अलॉटेड टू द दैट पर्टिकुलर मेंबर एट दैट टाइम बिकॉज द बालकनी वाज प्रॉपर रेगुलेशन में थे. तो while considering the existing carpet area, I should suggest that all developers or all the society members should consider balcony as the basic carpet area. Whatever the calculations are there for the fungible, that is a different story. लेकिन जो टेरेस एरिया है, जो टेरेस एरिया है जो फ्री ऑफ एफएसआई क्लेम किया है वो हम लोग कंसीडर नहीं कर सकते. हेलो
समाज सेवक ये कौन है, एडमिन कौन है? कैन यू मेक मी को होस्ट? पवार कौन है? अश्विन है?
हॅलो
अविनाश?
हा सर करतो मी, थांबा.
मला को होस्ट करना.
हा थांबा, मी म्यूट पण करतो, तुम्हाला को होस्ट पण करतो.
हॅलो
Coming to the next point.
हॅलो
Sandeep ji, there is a question. What is the time frame generally for obtaining IOD, CC, subject permissions and approval being in place? Is there any time limit for the developer to start the construction after CC is issued? Can you highlight on this? This is Sanjay Oak has asked this question.
Yeah, very nice. Yeah, very nice question. कि ये जो टाइमलाइन हमें चाहिए डेवलपर से, तो हम लोग टेंडर में ही ये सब इनकॉर्पोरेट सकते हैं कि वंस यू गेट सिलेक्टेड व्हाट शुड बी द टाइमलाइन, कि आप बेसिक प्लान्स कब देंगे, आप बेसिक डेवलपमेंट एग्रीमेंट का ड्राफ्ट कभी देंगे, उसके बाद में प्लान्स अप्रूव होने के बाद आप कितने टाइम में सबमिट करोगे, कितने टाइम के बाद आपका आईओडी एक्सपेक्ट है, कितने टाइम के बाद आपका सीसी एक्सपेक्ट है, सीसी के बाद का जो ओसी का जो पीरियड है वो कितने का है. ये फर्स्ट बेसिक टाइमलाइन हम लोग टेंडर में इनकॉर्पोरेट कर सकते हैं, ताकि क्या जो पीएमसी है उसके लिए वो आसान रहेगा कि वो क्रॉस वेरीफाई करने के लिए. जस्ट फॉर एग्जांपल, जैसे ही डेवलपमेंट एग्रीमेंट अपना फाइनल होता है और प्लान उसके साथ साथ डेवलपर सोसाइटी से अप्रूव करके लेता है, तो सबमिशन के बाद कंसेशंस के लिए फाइल मूव होती है. तो कंसेशन के लिए अगर आप कंसीडर करो 1 महीना या 2 महीने आप कंसीडर कर सकते हैं, और उसके बाद में आईओडी के लिए और 1 महीना. तो मैक्सिमम आपका जो आईओडी है 4 महीने में आ सकता है, और भी ज्यादा अगर टाइम तो मैक्स टू मैक्स 6 महीना आफ्टर द सबमिशन ऑफ द प्रपोजल. अदरवाइज 3 to 4 months इज सफिशिएंट टू गेट द आईओडी, बट उसके लिए सबमिशन होना जरूरी है. तो सबमिशन तक का जो टाइम फ्रेम है हमें डेवलपर से प्रॉपर उसका जो शेड्यूल है उसमें इनकॉर्पोरेट करके लेना जरूरी है. और सोसाइटी मेंबर्स का भी ये रिस्पॉन्सिबिलिटी है, जैसे जैसे डेवलपर उनको अगर डेवलपमेंट एग्रीमेंट का ड्राफ्ट देता है तो जल्दी से जल्दी अप्रूव करके देना चाहिए. जैसे प्लान्स का अल्टरनेटिव देता है वो भी फाइनल करके डेवलपर को देना चाहिए. तो ये सब चीजें दोनों तरफ से होनी चाहिए. अदरवाइज सोसाइटी टेक्स अ लॉट ऑफ टाइम टू फाइनलाइज द various things given by the developer. तो जब तक हम लोग दोनों तरफ से फास्ट नहीं मूव करेंगे तो IOD and CC जल्दी नहीं आ सकता.
Okay. Rotarian Ajay K. Gupta, he has asked a question. Is it better to go for detailed feasibility report such that all the issues related to overconsumption of area, height restrictions, CRZ restrictions, permissions are taken in advance? So what is your, is it better to go for detailed feasibility report in advance?
Yeah, Miss, जब हम लोग कुछ भी काम करने के लिए कौन सा भी काम, इट इज नॉट ओनली रीडेवलपमेंट, तो जितना डिटेल में हम लोग उसके ऊपर वर्किंग करेंगे दैट इज ऑलवेज बेटर. लेकिन सोसाइटी बहुत शॉर्टकट लेती है. शॉर्टकट की वजह से उसमें डिटेल फिजिबिलिटी वगैरह नहीं रहती. अगर आपको पहले एक बेसिक फिजिबिलिटी बनाने के बाद आपको डिटेल में फिजिबिलिटी करनी है तो आपको एक्चुअली उसका प्लानिंग करके देखना पड़ेगा. उसमें हाइट रेस्ट्रिक्शन के वजह से कुछ दिक्कत आती है तो वो दिक्कत के हिसाब से भी हमें प्लान करना देखना पड़ेगा. उसके एक्चुअल ओपन स्पेस डेफिशिएंसी कितनी आते हैं, कितने प्रीमियम्स आ रहे हैं, ये सब हम लोग अगर डिटेल में वर्किंग करेंगे तो वो हिसाब से हम लोग प्रॉपर डेवलपर को भी गाइड कर सकते हैं और यही हिसाब से हमें अपनी बिल्डिंग चाहिए ये बोल सकते हैं. बट उसके लिए आपको थोड़ा सा आपके कंसल्टेंट के ऊपर खर्चा करना पड़ेगा. मींस यू हैव टू अपॉइंट अ प्रॉपर आर्किटेक्ट, proper structural engineer who can make the plans, who can make the structural drawings, who can go for in the various authorities for जो कितना सिविल एविएशन का हाइट मिल सकता है. आपको ये भी करना जरूरी पड़ेगा कि आपका सॉइल टेस्टिंग भी करना जरूरी पड़ेगा कि आपको नॉर्मल फुटिंग्स लगेगा या पाइल फाउंडेशन लगेगा. अगर बेसमेंट आप करना चाहते हैं तो बेसमेंट में आपको माइक्रो पाइलिंग करने की जरूरत है क्या, विदाउट माइक्रो पाइलिंग भी आपका हो सकता है. सो ऑल दीज आर द डिटेल वर्किंग if you go ahead with the proper direction, but उसके लिए आपको सोसाइटी के लिए थोड़ा खर्चा करना पड़ेगा.
Okay. Advocate Amit Mehta, Sandeep ji, you be there. I have a few more questions for you. Before that, let me ask Advocate Amit Mehta. Amit ji, you are there? Yeah. Milan Mehta has asked a question, very important question. Can a society below 50 members select a developer out of tender if the tender received are unsatisfactory? What he mean is, the society has gone for a tendering, the tenders are received, but all the tenders are not satisfactory, and therefore now without further tender, they will take the offers from additional developers. Can they do that process if the tenders are not satisfactory?
Yeah, they can do provided general body approves it.
Okay, you mean to say general body is supreme and redevelopment GR, even if that is not followed in the true letters, but it is followed in the spirit, that is more than enough. That is what you want to say?
Yes, that is right. Number one. Number two, if there are 100% consent for any procedure, you don't require a 79A procedure.
Okay. Now, so many societies, when they appoint a developer and they don't, take the 79A directions. Okay. Now the registrars do, on the basis of some complaint, appoint an administrator, they take over the management and the redevelopment becomes stalled. So how we can tackle if such registrars take such extreme steps?
See, there are certain registrars who are sellable commodities and they just trouble the societies, even though most of the society members are ready for development. We can directly then challenge the matter in the DGR, there is a divisional joint register, or go to the Cooperative Ministry of Maharashtra. Subsequently, all go to High Court and challenge that such orders.
Hello.
Yeah.
Hello.
Yeah, who is that?
I'm Modi here.
Yeah, tell me.
Now, what we have just discussed few minutes ago, that if we have got a cluster redevelopment of 6,000 square meter and above area, okay, what about the road width?
Actually, there is 18.30 meter is the ideal road width for the cluster, but commissioner may consider a lower road width also, but it should be minimum 12 meter, more than 12 meter.
But then our area was going to go for road cutting. Can we say that little bit higher we can give it when the redevelopment will take place?
How much is the road width over there?
Personally, around 9 plus something is there.
What 9 meter? 9 meter.
Highway is there, but highway is a bridge.
Highway is a bridge, but below there is a service road is also there.
Service road and highway. So
highway
service road is around 9 meter.
Okay. And your plot is touching to that service road?
Correct.
Sandeep ji, what I suggest, you
Hmm.
can share your mobile number on the chat box,
Okay,
so that
fine.
you can interact directly. Because when it comes to a specific question, it becomes difficult.
Sure.
So, Advocate Amit Mehta ji, there is a question to you. If the ownership of the title of the society, Amit, are you there? Yes. Society does not have the conveyance. They do not have the ownership title. Can they still go for the PAAA or a DA? That is one question. Second is, the title of the flat is also in challenge. Can they go for the PAAA? These are the two questions.
For the first one, the answer is clear no. You need to have clear conveyance, and also before demolition, the name has to be there on the PR card of the society. That's as far as the first question is concerned. The second question, even though the title is challenged, you can still go for a development, sign at PAAA. But if there is an order of the court restraining not to do it, then you can hold it.
Okay. So that means if the title of the flat is not clear, still you can go for the redevelopment. There is no problem. As far as signing the PAAA is concerned, there can be some challenges unless until there is a settlement between the legal heirs. The PAAA may not be signed. Correct?
Yes. Yes.
Okay. So Sandeep ji, you have a question by Milind Mehta. Is the time taken for obtaining CC IOD is the same for residential as well as commercial building, or is there any timorate time limits?
No, it is the same.
Okay. Okay, Amit Mehta ji, if you can answer this, or I will answer that. The first question is GST. Whether the GST is applicable on the rehab portion. You are on mute. You are on mute.
You would be aware that there is a matter pending in the Supreme Court, and as far as the rehab portion is concerned, the answer is no. It is not applicable. But what happens? Many of the builders are not taking chances, and they're keeping that amount separately and telling them right now only you keep this amount separately.
Okay, let me explain to the participants. GST is a component which has to be recovered by the builder for the person whom he is giving the service. Now, there are two components which the developer constructs. One, he constructs the building and gives the constructed area to the existing members as per the development agreement free of cost. So the question is, when it is given free of cost, whether the GST is payable by the existing member. Right now, the government circulars and the provisions of the law is very clear that even on the free portion, because it is given as a service on the market value, GST is payable by the existing flat buyer. However, many DA contains a provision that even if the GST is payable, that will be paid by the developer. This is one way. Second, Advocate Amit Mehta has rightly pointed out, because it is a free of cost and it is given to the existing members out of the development agreement, and therefore GST should not be charged, and therefore the matters are pending in the High Court as well as in the Supreme Court. So till such time, the developers are taking a very conservative policy to recover such GST amount from the existing members and keep it aside. So, yeah. So any other questions on this? Yeah, Samir Vastani has a question. After the DA is registered, can a society back off or vice versa? Amit Mehta. Can the DA be terminated? That is what he is saying.
Yes, it can be, but through a procedure of law, because there are only two ways to terminate a registered document. It is either signing a deed of cancellation between both the parties jointly in consultation and mutual agreement with each other, or take a decree from the court if none of them are agreeing.
Okay, if the developer does not comply with the conditions put in the DA, okay, he should obtain the IOD within 6 months. Thereafter, within next another 9 months, 3 months, he should get the CC. He should start the construction, let us say, by within a period of 1 year. But even after 2 years, even IOD is not obtained. So there is no termination clause in the development agreement. For breach of trust or breach of contract, whether such agreement can be terminated. If it is to be terminated, what are the chances that the developer will win or the society will win?
Please note that there has been a judgment of the High Court and Supreme Court that even if a exclusive term of termination has not been mentioned in any agreement, the contracts are always terminable by either mutual consent or by the court. Please note that by not merely mentioning the clause does not mean you cannot terminate the agreement. That is number one. Number two, as far as the violation is concerned by a developer in a development agreement, please note that you can always go and terminate the agreement when you are able to prove that there has been a clear-cut violation, and the courts will be happy to terminate it.
Okay, Anand Gupta ji, you have some questions to ask?
Yes.
Yeah, please go ahead.
Amit Mehta ji, you pointed out that 50% of the building in Mumbai are not having occupation certificate. So what is the future of redevelopment of all these buildings?
So that is only a now matter of administrative formalities, because there are certain things that the developer at that point of time may not have complied with, and that's why the OC will not have been received. See, there are three types of defaulters as far as these buildings are concerned where OC has not been received. One, that a developer may not have complied with certain things at that point of time. So basically, example I'll give, drainage completion certificate. If he has not submitted, then he may not have got OC. There are certain things under the urban land ceiling at ULC where they would not have complied, then they would not have got OC. So that's the first point where the OC was not received. The second is non-compliance of certain payments. There are certain premiums which are supposed to be paid by the developer, and then as such he did not pay at that point of time. You may appreciate the fact that even though there are payments which are to be given in form of premium, there are also certain out-of-pocket expenses which are to be given. If you don't comply with some of them, then obviously the developer would not get, and the society as such would not get the OC. And third and most important thing, there are certain violations in the structure. These structures can be violated in two ways. One is that the developer himself has constructed, and secondly, some of the members who encroached upon or which were given possession in form of fit-out possession try to take on the balcony, the chhaja, everything into their flats. So there are structural changes. Once the structural changes happens, obviously the OC is 100% not going to be issued by you. So my submission to this forum is also one more thing, that please don't take possession unless until OC is received. Number one, don't be greedy enough to take a possession through a fit-out possession method. That will only violate some of the structures, because you may control your own flat, but you'll not be able to control the other 100 flats who are taking possession.
Okay, Sandeep, are you there? Sandeep ji.
Ramesh ji,
Yes,
can I ask?
Yeah, before you ask the question, let me ask Sandeep Kangutkar same question. No, your voice is not coming. 1 minute. Sandeep ji, is it that OC is a compulsory to get a free fungible FSI, or without OC also can we get a free fungible FSI?
There should be at least full commencement certificate.
Okay. That means if there is an authorized building which has the commencement certificate, and to the extent of FSI used on that as per the approved plan. So even if there is no OC, still you will be able to get a free fungible FSI, correct?
Yes, correct.
Okay. Is there any requirement that total number of members who are registered in the housing society through the register also has to be submitted to the building proposal department?
That is to take the advantage of the regulation 33(7)(b). Under the regulation 33(7)(b), the incentive FSI is given to the existing society. So suppose if there are 15 members and they are registered in the registrar's office, 15 members. So 10 square meter per member is the incentive FSI as per the regulation 33(7)(b). So it is 150 square meter. That much quantum of TDR we require to purchase less. So that is the advantage. That's why you should have. Otherwise, if in the registrar's book, if there are 12 members and actually you are 15 members, then BMC accepts the whichever is less, that is the 12 members. So the incentive FSI will be given on the 12, so 120. So the 30 square meter will be the society's loss. So in order to avoid such losses, we should make the all office records very proper, so that we will get the entire benefits what the government intends to give to the existing society members.
Okay, Advocate Mehta, Amit Mehta, can a mechanical car parking be sold or allotted by the developer?
Yes, it can be, because if there is a mention in the terms and conditions, you know that now parking is saleable. If it is mentioned in the agreement, the answer is yes.
Okay. Can the rehab members take the possession of the flat post part OC or even before the OC?
They can always take in the form of fit out possession, but my submission is that don't take till time the OC is received, even though it may be a part OC. Let the part OC come and only the portion which has got the OC take possession of that only.
Okay. So even post part OC of a rehab portion, they can take the position, correct?
Yes.
Now, if there is a part position, some of the builders do demand the maintenance charges from the existing members. Is it proper for such developers to demand maintenance charges from the existing members?
See, normally the developers would take a 12 months advance as far as the maintenance is concerned. The reason is like this, that till the time the entire society is formed, the maintenance ought to continue of the building. So there are chances that most of the developers would normally take a 12 months advance as far as maintenance is concerned, because it's very difficult then to maintain the society. So the answer is yes, as far as maintenance is concerned. But if already society is formed and it is a rehab part which has come, then the society should immediately take over the moment the possession is being taken by the society.
Okay. There is another question to Advocate Sandeep Kangutkar. There is 9-meter road available, but plot is rear the property of 100-meter far. Can we utilize all FSI benefits?
I have not understood this.
Yeah, even I have not understood. Who is that? Who has asked this question?
So whatever the question, he can address to me on my.
हेलो
Yeah. Please go ahead.
हेलो हाँ सर, मेरा क्वेश्चन था कि 9 मीटर का स्क्वायर मीटर रास्ता है विद 30, तो अंदर प्लॉट है ना 50 मीटर अंदर है, मतलब 100 मीटर अंदर है, तो ऐसा लॉ है कि एफएसए का बेनिफिट नहीं मिल सकता है?
50 मीटर अंदर है, लेकिन वो 50 मीटर जो अंदर है वहां पे कितना मीटर रोड है?
3 मीटर ही रोड है सर।
तो नहीं मिलेगा, नहीं मिलेगा।
नहीं, आपका सवाल ये है कि यदि
समझ गया,
आपका प्लॉट का अप्रोच रोड ही 9 मीटर होना चाहिए, आपका अप्रोच रोड 3 मीटर का है या 6 मीटर का है, तो फिर आपको बेनिफिट नहीं मिलेगा।
बाहर से 9 मीटर दिखा रहा है, अंदर जरा 50 मीटर के अंदर आएगा तो 3 मीटर हो रहा है।
नहीं मिलेगा सर, क्योंकि आपको टीडीआर का एडवांटेज नहीं मिलेगा। जो आपका एग्जिस्टिंग बिल्डिंग है उतना आप बिल्टअप एरिया कंस्ट्रक्ट कर सकते हो, लेकिन एडिशनल एफएसआई और आपको नहीं मिलेगा।
ओके। और एक क्वेश्चन था, पूछूं?
हाँ, पूछिए।
हाँ सर, अभी रोड है ना, एक है ना सर बीएमसी का रोड है जो हम 33 इयर्स से यूज कर रहे हैं, और हमारे प्लॉट में रोड ही अंदर दिया नहीं है, जो 9 मीटर 6 मीटर कुछ नहीं, खाली 22 विद एक्सिस पैसेज है ये अंदर बाहर आने के लिए। अभी 9 मीटर का जो लॉ आया 2034 का डीसीपीआर से, जो चिप प्रमोटर एंड डेवलपर रास्ता ही दे रहा नहीं, बोलता है तुम बीएमसी का यूज करो।
लेकिन ये
इसके बारे में आप डिटेल में ना संदीप कानूनकर से डिटेल में बात कर लो, उनका मोबाइल नंबर ऑलरेडी उन्होंने,
हाँ नंबर है मेरे पास, मैं उनको मिलूंगा सर।
आप मिल लीजिए, डिस्कस करिए। ओके,
थैंक यू।
शिव केतन का सवाल है संदीप कानगुटकर, our building has already used 1.7 FSI. As per the current DP plans, we can get 2.97 FSI, including fungible FSI.
Okay.
Can our plot, which is having 10,000 square foot, can we go for redevelopment?
Any plot can go for the redevelopment, provided that you're looking at the viability and the feasibility of the project. If the project is not viable, you should be able to put funds into that project. The redevelopment is possible. But whether it is actually commercially viable or not, that you have to first check it out.
Yeah, sir, can I ask you, sir? Hello?
Yes.
Sir, that's what we are in a problem, sir. Whenever we go to any builder, they are not exactly giving us a right reply, actually. Because our FSI, our 40-year-old, they already used 1:1.75, I think, some midland FSI. Then, so how do we come to know what is actually the commercial viable or not, basically? Because every builder takes you for a ride.
आपका प्लॉट कौन से कितना मीटर का रोड है आपके प्लॉट के सामने?
It is 12 to 13 square meter road है सर।
ओके, तो कुछ अलग रेगुलेशंस यूज करके अगर पॉसिबल है कि आपका प्रोजेक्ट वायबल हो जाता है क्या, दैट वी हैव टू चेक इट आउट। और अगर थोड़ा सा कुछ शॉर्टफॉल है तो आपके एग्जिस्टिंग मेंबर्स उसमें कुछ शॉर्टफॉल को फुलफिल कर सकते हैं कि नहीं, वो भी अपने को देखना पड़ेगा। देन वी कैन कम टू अ कंक्लूजन कि हम लोग रीडेवलपमेंट में डेवलपर के साथ जा सकते हैं कि नहीं।
So, sir, for that, do we appoint somebody?
Ketan, please understand that instead of going directly to the developer, you appoint a project management consultant, architect,
Okay.
let him find out various viability, because there is one regulation which Sandeep Kangutkar will now explain you, that is 3311. What is
Okay.
that 3311? In which there will, you can get nearly 4 FSI, and 1 FSI you have to give it to the government. So by using such benefits, it may become viable. So there are different regulations to explore and make the project viable. So you need to meet the consultant and understand that, and then you appoint a developer. Sandeep ji, can you explain a project which is not viable under the regular regulations? How can it be made regular under the transit accommodation policy of the government?
There are 2-3 regulations by means of which we can try to check it out whether in through these regulations also we can make a project viable or not. Number 1 is 3311, number 2 is 3312B, and number 3 is 3320B. And whether your existing building is having authentic OC certificate, then as per the approved plans, we can check it out. As per 33.7b, you will require to purchase 0 TDR. So all these factors we will have to check out, and then we can conclude that yes, we can go ahead with any of the regulations. So at present, this is not the right forum to discuss the viability of that particular. We have to check it out the various regulations, and then we will be able to conclude.
Okay, Advocate Amit Mehta, there is a question. Who is authorized to sign the development agreement? Is it all the members or only office bearers, or whether the members of the society should be made a confirming party? If members of society are made confirming party, what are the advantages to the society in the case of executing a PAAA? Sanjay Oak has asked this question.
Okay. As far as the signing authority is concerned, the managing committee is the final authority. However, the resolution can always be passed in a general body meeting. There could be some members who can be taken in the redevelopment committee, and they can also be simultaneously made the party as far as signing is concerned. As far as all the members are concerned, it is our humble submission that if you are taking the signature of all the members of society, there are both pros and cons. The benefit is that some members who are on a thin wicket ground, and they can sometimes back out, or they have some internal issues going on. It is better to take their signatures on the development agreement so that they are binded together with the society. If you take their signature, the advantage would be that no one will back out later on. So if all the members of the society sign on it, it is good to have them as a confirming party. So all the members do the vacating of the building 100% simultaneously. Otherwise, what will happen if some members are not vacating it? The cost of the developer will increase, and then litigation may start eventually. As far as the disadvantage is concerned of all these members signing, what happens if there is no clear-cut issue, legal hair issues within the families or within the signing authorities of a particular flat? These issues may sometimes crop up later on, and it may lead to multiple litigations. So if the society is 100% sure that all flats have 100% title clear and there are no internal disputes, then it is better to read their procedure.
Okay, Sandeep Kangutkar wants to go for one more meeting. Sandeep ji, can you conclude as to, for a successful redevelopment, there are 2 methods. One is the self-redevelopment, another is a development through the developer. So what is the modalities that you suggest for a society considering various litigations that is happening in the redevelopment process? Should they go for self-redevelopment? If they are going for self-redevelopment, what are the incentives and the benefits that the societies will get? And if they are going for a developer through model, what are the advantages and disadvantages? With that, you may thereafter leave, and other questions we and Amit Mehta will take you forward. Thank you.
Okay. So whether to go with the self-redevelopment or whether to go with a developer, that is the totally possible to take a decision once we finalize the feasibility report. Once you understand the volume of your entire project and what is the initial amount you require to raise the funds and to get the IOD, you will be able in a position whether your society is in a position to go for the self-redevelopment. Once you decide, yes, you are in a position to go for the self-redevelopment, because in a self-redevelopment also, you will require to raise some certain funds, at least to get the IOD. because any banking institution will start funding you after getting the IOD. Or suppose if you appoint a development manager, he will also not do the 100% funding for the self-redevelopment. So it is better first to think about your capacity for raising the funds for getting the IOD. Now for the self-redevelopment, the main advantage is that you are not giving your right to third party. So this is the first major advantage that you have. Then the second, whatever the planning you want to do in your entire redevelopment, that is your total in your control. And whatever the people you want to invite first as your funding agencies, that is also option available to you. But all these parameters, you will require to dedicate some time, you will require to raise some funds, and then all this time aspect is very important in the self-redevelopment. But if you decide to go with the developer also, you will require also to spend some time, but that is a limited. Once the developer is selected, he will take care of raising the funds, he will take care of selling the flats. It entirely will be his responsibility. Our responsibility will be to select a proper developer who has the capacity to do the entire construction very smoothly, and he should be able to give possession in time. That should be the care we have to take. That's all. And whatever the in details we have to go, that we will have to check it out with the feasibility and the various other aspects of that particular plot. Thank you.
We can just inform the participants that Maharashtra Society Welfare Association, by including about 50 experts, including Sandeep Kangutkar, Amit Mehta, and various experts, Anand Gupta also, we have come out with a book, Compendium of Self-Redevelopment.
Right.
In case you are interested in buying that book, it has got about 400 odd pages with the 23 chapters, 26 annexures, which is a very handbook for the purpose of going for redevelopment or self-redevelopment. Right. So you may decide to buy that book. It is available in Maharashtra Societies Welfare Association office, and you can take the benefit. Now, Sandeep ji,
yes, sir.
There is a provision that is about 13th September 2019. Government has come out with the GR promoting the self-redevelopment. In that, one of the provision was to arrange the loan through the Maharashtra State Cooperative or Mumbai District Central Cooperative Bank. And let me tell you that in between the loans were not given because RBI had come out certain restriction. Now the RBI has given the permission to Mumbai Bank as well as Maharashtra State Cooperative Bank to give the loan for self-redevelopment. So the self-redevelopment loans are possible. Secondly, in the self-redevelopment, there are one window clearance that Assembly, Devendra Fadnavis ji has already said in the Assembly that 13 September 2019 GR in a letter and spirit will be implemented, and immediately within 1 month, one window clearance will be given for the societies who are going for self-redevelopment. There are other benefits which are attached to the self-redevelopment. That is 10% additional FSI, concession in the premium, and so many other benefits are there, which are there in the GR dated 13 September 2019, which you may go through in detail. And I think, considering all these benefits, one should start exploring the self-redevelopment. And if you are not comfortable, then only you should go for the developers model. The reason being, if you appoint a developer, terminating a developer is a challenge. Instead, you explore all the possibility of self-development. If it is not possible, appoint a developer. So that by that time you have understood various intricacies related to the challenges related to the redevelopment, and then you can appoint a good developer. Otherwise, if you appoint a developer, then he comes out with the challenges and you are not able to digest, you are not able to terminate him, and it may create certain problems. That is the whole thing I need to say. Anand Gupta ji, would you like to say something about redevelopment from the builders perspective, because you are the RERA committee chairman of Builders Association of India also. So you can give us some insight as to redevelopment challenges as a developer.
Before I say anything on that, I would like to put a 3 question. See, sure. I know the answer of that, but probably answer of that will be really useful to a common man, and which I would like to hear from Ramesh Prabhuji and Advocate Amit, both.
Okay.
See, first, kindly re-endorse. You said that in case people who are not having occupation certificate and still want to go for redevelopment, they will be eligible for all the benefit of the redevelopment, provided they are having a full CC of that earlier building.
Correct.
Okay. Second thing, you kindly can you guide the people the people who wants to go for redevelopment but do not have conveyance, and they do not want to take also the pain of going for the conveyance.
Okay. See, I would only say that society should obtain the conveyance either through the developer or through under the process of deemed conveyance. Thereafter, they should have the property card in their name. Then only they should appoint a developer. There are so many societies who have not paid the proper stamp duty on their existing agreement. They do not have the required documents, and therefore they think that spending the amount on the conveyance or deemed conveyance will be a huge cost to the society. So they appoint a developer and then ask the developer to comply with all this and then go for the redevelopment. Yes, this also is possible. However, in that case, you should give enough time to the developer, because developer may take 1 year, 2 years, 3 years, we don't know. So you need to give that enough time to the developer, and only after getting the conveyance, you should execute a development agreement. Till such time, you should enter into a MOU, that is a memorandum of understanding with the developer, and you should not register the development agreement. That is the only suggestion that I can give it to the societies. So only after the conveyance and after the property
Can they not take the help of the present owner?
They can also appoint the present owner or the developer or the builder as the redeveloper. There is no problem. They can do that.
And then they will be eligible for all the benefit.
Then also they will be eligible for all the benefits. Yes.
And Ramesh Puji, my third and the last question is, see, in the beginning,
before you come with the question, please, Sandeep ji, Dharmendra Sharma sir, Sandeep Kangutkar wants to leave the meeting. You can just give a vote of thanks on behalf of the Rotary Club of Bombay West.
Yeah, so Sandeep ji, it's really nice to see you here and spare your valuable time to participate and give your valuable input.
Yeah, thank you very much.
Thank you very much. Let us meet sometime in person also.
Yeah, thank you. I have had a very wonderful session. Please continue. Thank you.
Thank you, Sandeep ji.
Okay.
Yeah,
Ramesh, third question. In the beginning, we said there are around 4,500 projects in Maharashtra which got stalled. Wrongly or rightly, they got stalled. What is the advice you give it to all the people, those who got in these 4,500 projects, how they get their house? What exactly you would like to advise them?
Okay, Amit ji, can you highlight on this? How to revive the stalled project?
It's a very actually open question, because we'll have to see case-to-case basis. It's not that all these projects have got stalled. There will be many of the issues which will be going in some project or the other. So we would better answer it on case-to-case basis with this very general question, which has a very general answer. How to handle it.
Yeah, I can only say, Anand Gupta ji, these are the projects, 4,500 projects. They are all called as a lapsed projects, which are RERA registered projects. So we need to look into in the two types. One which is RERA registered project, one which are not RERA registered project. RERA registered project means where the commencement certificates have come and the development has just started. And therefore, those projects which are RERA registered, the owners will be lying on the RERA. Now, as far as RERA is concerned, what they do is they definitely invite the existing developer to complete the project. And if the existing developer does not complete the project, then they advise the flat purchaser as well as existing society to come together and do it under the self-redevelopment, whereby invoking section 7 and 8, they will authorize the existing society as well as the flat purchaser to appoint a new developer and then go ahead with the redevelopment. We have handled around 5 projects which were stalled during this one. One I can talk about Gitanjali Infra at Borivali, which was started by Mehul Choksi. And Mehul Choksi has left India and the project was stalled. RERA could appoint a new developer and get the project completed. Like this, there are SRA, MADA project, various things. So as Amit ji has rightly pointed out, we need to analyze and understand the intricacies involved in each of the project. We need to meet the existing flat buyers. We need to meet the new flat purchasers and then bring out some solution. And also some haircut may be required to be done by the existing members also in place or in view of giving up the corpus, giving up the what is called as rent, and new flat purchase may have to contribute some additional money so that project becomes viable. There are some projects which are mortgaged to the various financial institutions, and there are SURFACE which has been invoked, or NCLT provisions are made. In that case also we need to see how a project revival plan can be prepared and it can be taken forward. So these are all case-to-case basis, but naturally more than 50% of projects are viable, they are doable. Only thing, because of the various litigations, things have become stalled, and RERA can definitely intervene. And the projects which are not registered with RERA, naturally they have to go through the legal process, either through the arbitration or through the city civil court or through the high court, wherein they need to terminate the existing developer and appoint a new developer or go in the self-redevelopment. Okay, thank you, Anandji.
Thank you.
Now, Amit, there is a question to you by Ketan Kamath. Amit Mehtaji, our society has a conveyance deed, but PR card, Malmat Patrak does not bear the society's name. It is still in the builder's name. Do the society need to get this name on the property card first and then go for the redevelopment, or what is your guideline on this?
Yeah, if the same builder is continuing the project, then you don't need to do it at this point of time. Otherwise, it is advisable to first put your name and then continue for development.
Okay, Seema Seth has a question. What about litigations on the prospective developers? Is it safe to give a redevelopment to such developer whose balance sheet is around 25 crore and who says will join the hands with the XYZ developer? That means they have got various litigations. The developers are having, various litigation background, and they are saying that we will involve another developer and we will complete your redevelopment. Is it advisable to give the redevelopment to such developer?
I don't want to know the name of the developer, but of course, in such situation, I would prefer the answer is no. It is better to have a clear-cut developer who has funds available with him, unless until he has a track record where he has already completed so many projects without litigation and had earlier funds, but now he doesn't have funds. Then I can still consider. Otherwise, the answer is no.
Okay. We want to arrange a self-redevelopment seminar in our society. Please advise. Yes, anybody who wants to arrange a program in their societies and or in a local area, Mahaseva with Rotary Club and other associates like Amit Mehta, Sandeep Kangutkar, we will be very happy to be a part of such programs. There can be, if it is a one society redevelopment, there may be certain professional fees involved. Otherwise, if it's a public program, it can be done on free of cost. So the next is there any other? Yes. 3311 does not, passing authority does not go to BMC or SR authority as being society registered in BMC. Does the society come in MADA or SRA? Rachna has a question. Amit, if you can answer, otherwise I will answer.
Yeah, I can throw only one light on this.
Yeah, 3311.
Yeah, 3311 it is called PTC. That can be, it's a new trend right now because it gives some extra FSI to societies. So if the society is willing to go for this particular scheme, then it is advisable to take this scheme. You may get a little extra benefit in that.
Okay. There is another question by Atul. Sir, please highlight the difference between MOFA and RERA. FSI calculation in suburb area. So, Mehtaji, can you highlight what are the difference between MOFA and RERA? Legal provisions.
See, the MOFA and RERA has nothing to do with the FSI. FSI is purely related to the plot of the property. But MOFA and RERA, obviously, you would know that MOFA was earlier there till 2016. And after that, it got abolished, and then RERA continues from 2016 onwards. And we all know the benefits of RERA over MOFA. The good part about RERA is the civil courts are now sidelined as far as the RERA is concerned. You don't need to go to the city civil court. Now, if they are directly go to the RERA appellate court and directly to the high court. Earlier, the city civil court used to take a lot of time. You still have the option of going to the consumer court. But the good part about RERA is another advantage is there. It is time bound. So what happens once the case is filed in RERA, it is time bound, it is disposed of in a time bound way. And though I was a part of the RERA drafting committee, and it was a highly neutral type of the bill which was introduced by the government of India. But I am still of the personal opinion, it is highly still pro-consumer and which is the advantage to all of us.
Okay. So I can just tell you that Maharashtra Ownership Flat Act was the act enacted in the year 1963 prior to enactment of RERA. And this is mostly related to Maharashtra, whereas RERA is a Real Estate Regulation and Development Act across India. Now, in the MOFA, certain provisions or the compliance was required to be done by the developer. Obligations were cast on the developer. And if he does not comply, we could go to the city civil court, consumer court, or in the magistrate court and book the developer. Whereas in the case of RERA, you don't have to run pillar to post. Even before the sale of the flat, the builder has to get the clear title, commencement certificate, and all the approval in place. Thereafter, the RERA project gets registered. Thereafter, only he can sell the flats. And there is a lot of transparency which is available in RERA. And as far as litigation is concerned, now you will be able to go only to the RERA, so that all other provisions are, of course, not available. You need not go to city civil court. But of course, consumer court is still available. Now, as far as FSI in suburb area is concerned, if the road width, it all depends on the road width. If it is more than 9 meter, up to 12 meter, of course, it is 2.7 FSI. There is 1 FSI, 1.5 premium FSI, 0.5 TDR, this way 2, and then 35% fungible FSI. If it is 12 meter and above up to 18 meter, of course, it is again 2.2 FSI. Then 0.5, you have got a premium FSI, 0.5 you have a TDR, then it becomes 2.2, plus you have fungible FSI. That way it becomes 2.7. Then of course 2.4 also is there, plus fungible FSI, depending on the road width. And if it's a cluster development, there is 4 FSI plus fungible FSI. So these are the various norms as far as FSI is concerned. But of course, as I said, you need to go through the process. You have asked for the name of the book. It is a compendium of self-redevelopment, authored by IAS officer, retired IAS officer, along with me and other 50 co-authors. That is compendium of self-redevelopment. Next question is, in the redevelopment, if you want to buy the extra area from the developer, then how much percentage less they can compare to the sale price? Amit ji, can you answer this? In the redevelopment, if you want to buy extra area over and above the free area, what should be the rate or percentage discount that we can expect from the developer?
See, normally the formula they use is we'll give 10% discount, but please don't go into this trap of 10% discount. This how do you arrive at the market rate? See what happens. Developers normally tell, "Ki, sir, I want 10%." So developer will tell, "Okay, I'll give 10% on the market rate." But now, how do you arrive at the market rate? So there are two formulas how we can get the market rate. First, understand the ready reckoner rate of that area. If suppose in the ready reckoner area of, say, example, let's take Andheri. If the ready reckoner area in Andheri is, say, about 18,000 or 20,000, ready reckoner area, ready reckoner rate I am talking. Okay, the market rate could be about 25 to 30,000, which normally is about 20 or 25% extra. But how we arrive at it, we take the quotation from 3 brokers of that area. Okay, we understand what are the actual rates going on. 3 independent brokers who don't know each other, we take their quotation, we arrive at the average rate of those 3 quotations. That becomes a market rate. And then you calculate and reduce the ready reckoner rate. That difference is there, on that you negotiate. And then you take the discount based on that, which could be about 10 or 15%. So arriving the market value is more important than actually taking the discount. You may just give more, he may give more discount, but he is giving you higher market rate.
Correct. So it is a very, very good formula you are given. It is very important if you can be included in the DA itself. Many of the societies, they include the price for the extra area in the DA itself, and they also give how much is the additional area they can purchase at the discounted price. So instead of keeping it open, it is better in the DA itself. You mentioned that additional area to the existing member up to additional 10%, they will offer at 10,000, 20,000, 12,000, whatever the rate prevailing, that can be mentioned. That becomes much easier. Lakshman ji has a question, Advocate Mehta ji. PAAA has been signed by the nominee and his brother has challenged the same. Even the society has challenged. So what is to be done?
No, PAAA, how can the society challenge? Because the PAAA cannot be executed if the society is not a party to it. The society had to be party to that.
Correct.
So it is very difficult to understand how the society is not party to a PAAA. However, let's give
Lakshman, are
benefit
you
of-
there? Lakshmanji? Lakshmanji, can you explain this? Okay, no problem.
Hello, hello.
Yeah, Lakshman.
PAAA has signed by the elder brother.
Okay.
The younger brother has sued the society. He has
Okay.
taken the society to the court.
Okay, okay, okay.
The brother and the younger brother has taken the society to the court.
Okay, okay. Understood. Yeah, go ahead, Amit.
Yeah. So I presume that the society is a party to the to the PAAA.
Correct.
PAAA cannot be
He is a
independently
party,
executed.
and therefore younger brother has challenged it before
Yes.
the court
Yes.
against the society.
The
also
society and
for
the elder
executing
brother.
the PAAA.
Yeah. So that is okay. Let the courts decide whether who is the right nominee and who is not.
Correct.
Yeah.
Sir, PAAA can be executed even with the nominee, because at the end of the day, nominee is a trustee. Nominee does not get the ownership. Just because the PAAA has been signed through the nominee does not mean that he becomes the owner. Many of the people are under the misconception. If you don't execute a PAAA, commencement certificate does not come. If there is a dispute between the nominee and his brothers and other legal heirs, how can society keep quiet? And therefore, we also have received one High Court judgment directing the society to execute the PAAA through the nominee, with the nominee, and then leave the nominee to bring other legal heirs on the record later on. This is just a accommodation that PAAA will have a clause that PAAA has been executed with the nominee, and it is the responsibility of the nominee to bring a legal heir and execute the subsequent deed with the legal heirs. So this can be done. Otherwise, if you don't do the PAAA, you do not get the commencement certificate. So therefore, this is very important. Sir, Amit Mehtaji, you have a question by Milan Mehta. If a developer does not give the bank guarantee and shows funding from own company, but not give solvency certificate also towards his capacity, does it not clearly point out a big risk to the society?
Yeah, the risk could be there, but you need to do a proper due diligence. It may not be necessary that because he doesn't give bank guarantee, he is not solvent enough. Because bank guarantee also cost more today. Earlier, the 20% amount was to be deposited, then it became 50%. Now it is 100% deposit to the bank if you want to avail a bank guarantee. Please note that getting security doesn't mean that you are getting the best of the security. This security also means that they will cut corners at somewhere else, because it's a cost. It's a cost to the developer. So from where will he recover this cost? He will recover the cost from the society. So merely getting a bank guarantee doesn't mean that you are safeguarded in 100% way. It only means that you have some safety by which, if there is a dispute between you and the developer, then there are certain things by which you can encash it for some point of time till the time your members can survive on the rent, which can be encashed through this bank guarantee.
Okay. Now we will take another 2 or 3 questions. Dharmesh, can we conclude after 5-10 minutes?
Sure.
Yeah. So we'll take one question. Builders are now refusing to give bank guarantee. Okay, Amit Mehtaji. Builders are now refusing to give bank guarantee. They are giving lien on a certain flats in the project. Which one is better for members of the society security? Bank guarantee or a lien of the flats, which is better?
Obviously, bank guarantee is better. The lien of a flat is somewhere which is in the air, and you don't take something in the air as a security. However, I can give one tip to all the members who are participating today, what we as lawyers do. And this is a very unique idea which you have started taking. If the builder is not ready to give a bank guarantee, and if the society agrees to take the lien of certain flats, and these flats are those flats which are in the air, then we also take an equivalent amount of a post-dated check, which is not dated, which is undated, of equivalent amount. And that can be kept as the escrow guarantee that in case the developer fails to proceed ahead or fails to complete the project, then this check can be deposited with a certain escrow letter. In that, a specific line will be written that this check will be deposited by the society to the bank with no further reference to the developer in case the developer defaults in the terms and conditions of the development agreement. So if you are taking the lien of a flat, this additional coverage you can take, and this the developers will happily give. The reason is that their money is not getting stuck. It's still a check only. There is no certain amount which is getting stuck. So you get an additional double layer of benefit as far as security is concerned.
Okay, if the lean flats are already constructed and there is a OC, maybe of the already completed another redevelopment project, is it advisable to take such flats on a lean?
Yes, that would be advisable. Then better take a lien of a flat which is not in your building, in your rather proposed building, and from another building.
Okay. Would you appreciate reply to questions about 33.9? So 33.9, there is a question that what are the various benefits under 33.9? That is a cluster development. Please throw some light on the responsibility of the developer in the case of 33.9 cluster development vis-a-vis MADA flats, etc. in the western suburb. So shall I answer this, Amit?
Yeah, in 33.9, I would not be able to in a capacity to give a lot of light on that.
Okay. See, there is no difference between 33.9 and 33.7 or any type of redevelopment. Let me tell you, whether it is through the premium FSI, other thing, all the responsibilities of the developer remains the same. And it becomes once the developer takes a cluster development, then certain area need to be given to the MADA as a part of the DCR provisions, and that has to be given by the developer. It has nothing to do with the society. So therefore, you don't have to worry on that aspect. And the second question you are saying, Mumbai City, hardly any projects are registered with MARERA. No, let me tell you, because the redevelopment in South Mumbai is not happening the way it is happening in suburb. And therefore, you don't find many, this one, RERA registered project in South Mumbai. But if they want to sell the flats, naturally it has to be registered with MARERA. Otherwise, they cannot sell. So therefore, I'm not very sure that without RERA registration, they will not be able to sell the flat. Now, for redevelopment, just one question. Okay. Now, for redevelopment of community, is a property card mandatory before signing the DA? As we have already said, that unless until you have a property card in your name, it is not advisable to sign the development agreement and go for redevelopment. Otherwise, it will attract a lot of litigations. Section 41, exemption from compulsory. Can we get this facility on the redevelopment? The answer is no. Section 41 of the Maharashtra Cooperative Society Act says, in case you want to transfer the shares, then agreement to transfer the share need not be registered. But that does not mean that redevelopment agreement need not be registered or PAAA need not be registered. They are all wrong. So with this, I think Amit ji has given a very good suggestion that in case the developers are not able to give the bank guarantee, you can take a check including the lien of certain flats, which will facilitate. And Amit ji, you can conclude some of your suggestions to make the redevelopment a successful. How the redevelopment can be made successful in the various controversies. One, regarding the dissenting member, how to handle the dissenting member. Secondly, if the developers are not starting the projects the way they have promised, how we will be able to encounter. And the third and most important is when the project becomes stalled, then how we will be able to use the legal system to get the project revived. These are the three simple questions, and you can conclude.
Yeah. So, of course, as far as dissenting member is concerned.
Hello. Mr. Amitji, I am Uday Kalbak.
Yeah, hi.
I have one. Hello.
Yeah,
very good morning to you, Amit.
Hi.
I have one question. Just now we were discussing under 33.9. In that there is one clause that if there is an open plot or some public property or some public undertaking properties, and if those properties are contiguous to the plot under consideration for redevelopment, then a developer can purchase that plot by paying the proper consideration to the private property or MADA or whoever is the owner of that MADA. In this case, whether such at what rate is suppose that MADA is the owner of that plot, then what is the rate MHADA will purchase, will sell that flat? That is number one. Second thing, in Bombay, under MHADA, whether such things has happened, whether MHADA has given or sold that property to the developer or the society.
Yeah, so there are two aspects. One is the plot of a, say, BMC or a collector or a MHADA, and second is the property which are there in their name. So there are certain cases where collector land has become a freehold land from collector land. There was a scheme which had come about a year before, where you paid a 15% of the amount of the ready reckoner rate, and the plot becomes of the society or the developer, whoever is purchasing. As far as the property is concerned, the BMC and MHADA, there are no such cases where they have sold off their property. But there are schemes where they have given it on a long lease for 19 years or n number of years or 30 years. And then the property is there with the society for a longer time. But the collector land has been sold and they have become from leasehold to freehold by paying certain premium, which normally was 15% recently when the circular had come.
Okay,
yeah, I will just add, Uday, I understood your question. See, let me tell you, if there is a plot which is owned by the MHADA and you are expecting them to sell it to you, then what
sale or lease?
Use? Huh?
Sale or lease?
Yeah, sale or lease. Naturally, there are various methodology. You need to approach MHADA VP, and then of course they will calculate as per the ready reckoner value. Certain premium will be levied to you, and you will have to pay the premium. That is a lease premium, and get it. But what will be the exact amount of the premium? All this will be connected with the ready reckoner value. Okay.
No, my question is whether in such case, hello.
Yeah, go ahead.
Hello. My question is whether MHADA in such case can refuse to give it, even if it is mentioned of 39 policy.
Yeah, they can do. We can discuss further. You have a number of Mr. Amit Mehta as well as Sandeep Kangutkar. You can discuss with them separately. Okay.
We have put our details on the chat box. You can see our details on the chat box. I put the email ID and the mobile number also in case required.
Yeah.
Prabhu sir, please one question from my side, please. This is Vandana here. Now regarding the checks, Amit Mehta sir said you can take checks from the developer. Now if the check bounces, then there will be one more cases going on, like here the building will be demolished, and I mean, don't you think this is a very lengthy process? It's better to take bank guarantee always, but our developer is not ready to do so. Any other options, sir, besides the lien and check you mentioned, right? See, because we want our building to be completed in 3 years. But with this litigation going on, then it's very difficult for us to come back to home, right?
See, what is the stage of the project right now?
The thing is, our committee is we have got the deemed conveyance, but we don't have the property card yet in our name. But still, the management committee is going ahead with the builder of their choice. And a few of us had disagreed with it. We are saying until property card is in our name, then only we should go for the DA. So I need a suggestion on this, sir. As Prabhu sir mentioned, yes, there will be litigations, but our managing committee is not ready to agree with this. So what are the this thing? Can you guide me on this, sir? It's very important. Hello.
Yeah. See, Vandana, let me tell you. First and foremost, the check bouncing. If the developer is not ready to give bank guarantee at all, and what is the next option? Naturally, take the check so that if at all he is not giving you the amount or honoring the check, then of course you can file a criminal case and put him behind the bar. So that becomes a deterrent factor. That's it. Now,
I just want to know, Ramesh, 1 minute. I want to know, Vandana, from Vandana ji, how many member society is this?
Ours is 50 members, sir. 50 members, corporate.
50, and 3 are opposing.
Yes. Because there was 79A was not at all followed. There was no tender, nothing. The chairman or committee member bought this builder, and they just started working on it. Most of them are defaulters, so they are happy with that redevelopment by any builder. But I feel once the building is demolished, there's no way this builder is going to give us a building on time, because there was no annual report or nothing feasibility, you say financial strength, you know.
Okay, he has understood. Yeah, go ahead.
Yeah.
Amit.
So what I'm suggesting, see, it's a very unique case. It should not happen that you are actually right and the majority are wrong. And even then the project has gone ahead. But the fact is that because you are in minority, the courts in India today may not consider minority so seriously unless until you are extraordinary case. Under the apprehension that he is not going to do some sort of things, when your apprehension may be right, the courts will not support you because you are apprehending certain things. Unless until it's a tested case and there have been cases against them prior to your project, then obviously then some questions can be raised. But otherwise, I am of the opinion that try to see technically their balance sheet, profit and loss statement. Even though the committee is not cooperating, you can also take out through private route and take out their solvency levels, and that you can always circulate it to the entire society that this is a solvency level and that you are apprehending that you will not be able to complete the project.
So what do you mean by private route? Can you just enlighten on that?
Do one thing, Vandana, you take his number. You can. I also shared my number. We can discuss separately. Now,
okay.
last question. Lakshmanji has asked.
Thank you.
Stamp duty on descending member and when it triggers. Lakshmanji, let me tell you that if you are a descending member and you have not signed the development agreement as a conferring party, then on the descending member, stamp duty will be payable as per the construction cost, and construction cost on the entire area, including a free area as well as the existing area, and on that 6% stamp duty is payable. If you are a conferring party in the development agreement, then stamp duty is going to be only 100 rupees. So therefore, it is advisable that if you are a minority, then better to sign the development agreement so that your DA, everything will happen and it becomes so much convenient for you. Now, the last question by Chandrakant: what benefit society has to get when the lands has to become freehold and the redevelopment is final stage? See, if the your collector land becomes a freehold land, naturally, in future when you are going to sell the flats, you don't require the collector's permission. However, if it is not a freehold flat, still you need to give 10% of the land area as a premium to the collector government to get the development agreement signed or redevelopment done. So therefore, it is advisable that you pay 15% of the land cost and become a freehold. By paying extra 5%, your project becomes freehold. So therefore, it is better if you can do the redevelopment. Rajesh Nambiar, with the introduction of RERA post 2006, what is the mechanism of applicability of MOFA for existing members in the legacy project? See, MOFA and RERA both are existing. It is not that MOFA has been repealed. Government is planning to repeal, but right now it is not repealed. So you can take the benefit of MOFA also to initiate action against the various people. So with this, I request Dharmendra Sharma, the president of Rotary Club Bombay West, to give his final wording, and then Anand Gupta ji will give the vote of thanks. Thank you very much.
Thanks, Rameshji. It was a very interesting seminar, and every participant and the speakers have enlightened all of us. So, due to the time constraint, we have to complete the session. So, I would like to invite our past president Anand Gupta for offering a formal vote of thanks.
Good afternoon, friends. Friends, as you know, this has been a joint venture of Rotary Club of Bombay West and Mahaseva, and we had organized today 55th lecture. Continuously last 4.5 years we are organizing this, and this is happening continuously. The next lecture is going to be on the 5th of February, and which is going to be on the structural audit and repair. Friends, now present task of giving a vote of thanks to all the guests have been given to me. So first, our thanks is to Advocate Amit Mehta, who has been the author of the RERA Act in the country, who has been also one of the author in for the RERA Act. As he rightly pointed out, the RERA has brought the uniformity throughout the country for all the rules and regulations for housing, and it has definitely brought the credibility of all the developers and in the system. He also very nicely explained the importance of 79A and how fair, if everybody follows it, it will bring the transparency and the accountability, and the chances of any litigation will also get reduced. He also nicely explained the importance of appointment of project management consultant, feasibility report. He also pointed out what care we should take while pre-qualifying the developer for tendering. He also pointed out the various importance of the registered development agreement and the consequences in case we do not have the registered development agreement. Amit ji, thank you very much for sparing your time and inviting all our delegates for redevelopment.
Anand, thank you so much for giving such a nice small Thanksgiving speech. Thank you, Dharmendra ji, Ramesh Prabhu ji. We also have dignitaries here. Tarun Mota ji, very senior architect. He is also there in this for quite some time. Thank you, Tarun Mota ji, for being part of this program. Kanji Rita ji, who is a very seasoned developer, he is also there. And Samir Hingu, who has been part of the P8 also. So all these people also very silently and nicely heard the entire discussions.
Yes. Abhijit, similarly, I also would like to thank in his absentia, architect Sandeep Kangutkar for sparing his time and explaining the self-redevelopment and the importance of the road width, importance of the cluster development, and various aspects of the FSI, the fungible FSI, etc. Similarly, I also would like to thank our housing guru Ramesh Prabhuji, who has been the instrumental for organizing this lecture series from last 4.5 years. And similarly, I also would like to thank my own president, Dharmendra Sharma, who has been the leader and contributing for community service. And how can I forget all the delegates? And as rightly pointed out by Amit ji, various important guests have come. I also would like to thank all the delegates and all the VIPs participated in this lecture series. Thank you.
Thank you. Good day.
Thank you.
Thank you, Amit bhai. Very good. Bahut
Thank you.
saras.
Thank you, Kanji bhai. Thank you for attending. Thank you.
Avinash, conclude karo. End the meeting.
Okay, sir. Thank you.